Hello there. I'm Rob Hudson, a member of the law firm Frost Brown Todd. I'm a volunteer for the Northern Kentucky Bar Association, and it's my pleasure to welcome you to our Legends series. Through its Legends series, the NKBA presents programs to recognize high-performing members of our profession. We focus on practice excellence, practice development, ethics, and professionalism. Plus, we get to hear from people who've impacted our region through the practice of law. For our live attendees today, if you have questions, send them in via the Q&A or chat feature for the program, and we'll address those at the end of our program. And I think it's a very big day for our Legend series. We welcome NKBA legend and longtime federal magistrate Judge Greg Wehrman. To say that Judge Wehrman is trusted and beloved in Northern Kentucky is not hyperbole or flattery, it's just the truth. I had what I thought was a nice introduction for Judge Wehrman ready to go, but instead I'll just share a short personal testimonial or story about my experience with Judge Wehrman. I was a young lawyer. I had a case that was a little outside whatever bailiwick I had at the time. We had a settlement conference in federal court. I did a report on the case, and I was a little uncertain of it. And again, not really my bailiwick. It wasn't a labor and employment law case. And we went in, and early on in the conference, when we had a breakout session, Judge complimented me on the pre-hearing or pre-mediation submissions. And it's that kind of encouragement that makes a huge difference, I think, in a new or younger lawyer's life. It had a profound effect on me as an attorney at the time. And since then, of course, I had several subsequent conferences with Judge Wehrman, and he inspired trust and a comfort level where you could be candid about how you viewed a case. And I thought all of that, with its approach and style, it moved people together in the context of mediation. And I think that's one of the big reasons why Judge Wehrman is truly beloved in the Northern Kentucky Bar. He had more than 20 years of private practice, more than 20 years on the bench. He's seen and heard it all in the legal profession, and we're really lucky to have this opportunity to hear some of that today. Judge Wehrman, welcome to our NKBA Legends program.
Thanks so much, Rob. Thanks for that very nice compliment. That's been a long time ago, and I appreciate your comments. But so you know, Rob, when I retired and I was still doing some mediations, I was following the exact same procedure and policy as when you first came in some many years ago, because it's accurate and it works.
Well, and that's one of the things I look forward to today, talking about the style for conducting mediations, of bringing parties together. But let's start out with the beginning in terms of your decisions to become a lawyer, your early experiences, and then we'll move on into some of the more substantive points. I know you came from a Northern Kentucky family of lawyers. Did that early exposure to the law shape your career choice and pique your interest in the law?
Most definitely it did. My dad was a county attorney in the 40s, and then he was elected county judge in the 50s. And as a kid, I would follow my dad down to the courtroom. In those days, and this was the early 50s, the main misdemeanor court was on Saturday morning in the old courthouse, and it was a real show. And I loved going down as a kid, watching my dad sit on the bench, hearing these cases. And that's where I got to meet, again, as a youngster, I got to meet a lot of lawyers who influenced me to some extent when I graduated from law school, like Hal Vincent and Jack Howe, names maybe some attorneys don't remember, but who had extensive trial experience. And that was really influential, really helpful to me, just to watch them in action as a kid. And then when I got older, following in my dad's footsteps, my older brother Barry became a lawyer, my brother Bill did, and I was the last one to join the firm. So it started from the beginning.
Well, when you joined the firm, I assume you didn't start at the top there. If you could tell us a little bit about what your early tasks were in the law as you were a new graduate.
No, I know, Rob, I sure didn't start at the top. When I was in law school at UK, I tried to work my schedule out so I could come home on Fridays, and I would clerk. I would do whatever my dad or my brothers needed done. And that meant running back and forth, just like paralegals might do today, taking deposition notices, interrogatories, filing them down to the clerk's office. But that also meant, and sometimes, like Hal Vincent's office is right near the courthouse, I just drop copies off at his office. And that gave me the opportunity to have brief interactions with attorneys who I otherwise would never have gotten to know. And there was a group of attorneys who always gathered together on Saturday mornings after court. They went over to the breakfast place right across the street from Whitey Miller owned it. And I'm having one of my senior moments because I can't think of the name of the place, even though I was in there many times. But that was the time where lawyers got together, and these were lawyers, of course, who went into court. Although I remember John Cleat came in there plenty of times. Everybody knows John Cleat was the ultimate title lawyer in Northern Kentucky. And as a youngster, I got to watch and participate and listen to their conversations, which were just remarkable. But also helped me get to know the attorneys pretty well. And so
Judge Dean Pisacano has weighed in and said Shelby's Restaurant.
What did he say, Shelby's?
He said Shelby's Restaurant. I don't know if that's accurate or not, Judge.
With all due respect to Dean, he's wrong. It's not Shelby's. It's not Shelby's. It'll come to me. I mean, that's not the name, but it doesn't make any difference. I just enjoyed that time, and I really had some great opportunities.
And now Dave Davidson says it's Whitey's.
That's it, Whitey's. Oh, very good, Dave. Very good, Dave.
It looks like the attendees are taking over. That's really a good thing. Judge, early on with some of your choices, as far as how you spent your time practicing, if you could share with us some key early choices that helped you develop knowledge of the law and practice excellence.
I would follow and sometimes assist my older brother Barry in the courtroom. When I started practicing, it was October of '69. That's been some years ago. And he was doing a lot of criminal work. And so I would go into the courtroom with him. It's just helping whatever I had to do. And then he branched out into some civil work. So I got to watch the best of the lawyers in the Northern Kentucky, Cincinnati region, try cases. And it's like a bird sitting on a branch and listening to the best speeches and the best talks and the best judges. And I was fortunate to have that opportunity because I really did learn a lot. And not only did I learn a lot about litigation and trial work, but I also saw things that I really didn't like. And that's when attorneys would get angry and lose their demeanor in the courtroom because of objections, because of sometimes personality conflicts with the adversary. And I saw more than one time lawyers who lost cases because they did not keep their cool. That term wasn't in use back then, but everybody knows what I mean when I say they did not keep their cool. And I made it a point then to say, I don't ever want to do that. I don't ever want to get so upset in the courtroom that my temper comes out, accusations start to fly, and the judge has to interrupt. And I made sure that I followed that rule. Every trial lawyer knows that when you get in the courtroom, there will be flare-ups. There will be instances where you're shortchanged and you get angry. But the most important thing is, do not lose your demeanor. Do not lose your composure. And thankfully, I learned that at a young age. And that carried over to me on the bench too. It's very important lesson.
Well, Judge, I understand that early on you made a choice to do some public defense work, public defender work.
Yeah.
And so I assume you were able to go in then and try cases at a younger period or newer period shortly after graduation. Tell us about that and what impact that had on your development.
Probably the biggest impact on my career, because I started off in federal court in front of Judge Swinford, Max Swinford, who was, when you use the term legend as this interview is described, he was a legend. And he was a traveling judge. So when he came to Covington, he would be there for a couple weeks, and the criminal docket was very heavy. And so he would try cases one after another. Plea bargaining wasn't to the extent that we have today, or certainly not from the time I went on the bench in '92. And so a lot of cases got tried, and a lot of those defendants were indigents. So I signed up to be on the CJA Criminal Justice Act list, and boy, did I get an education. We started. Judge Swinford thought if you had a half hour to talk to your client, you should be ready to go to trial. And everybody jokes about that, but he was a wonderful judge. I learned a lot from him, but he expected you to be ready to go because of his docket. And so I did. And I started defending cases down there, and I was up against usually Jim Earhart, who was also another legend, Jim Cook, and Gene Seiler, who's of course Court of Appeals judge now. And you talk about defeat building character. Well, in all the years, I started doing my trial work in 1970, early in 1970 in federal court, until I was appointed as a part-time magistrate judge in 1975. Judge Swinford died that year. And it was not unusual to try 2 cases in a week. Sometimes he'd start a third case. And that's just the way the criminal docket worked. But he was so much of a gentleman on the bench. He was always kind to the lawyers, and he showed a demeanor that everybody respected. Everybody respected. Doesn't make any difference whether on the civil side, whether you're plaintiff or defendant. He just had that respect, and that carried over to the Sixth Circuit too. He had a great deal of influence in his decisions. So I'll tell you a real quick story. One of my first cases in front of Judge Swinford was what they called a Dyer Act, which is interstate transportation on stolen motor vehicles. So Covington, Cincinnati, Newport, Cincinnati, that was a big portion of their docket back in the 70s and the 80s. And I just completed a Dyer Act case. Jury went out, and Judge Swinford said, "Gentlemen, let's start the next trial," which was me. I was going into another trial, another criminal trial. So we get into the trial. The jury is, of course, sitting in the courtroom, avidly watching the case, and the jury that's out deliberating comes in with a verdict. Judge Swinford says, "Gentlemen, step aside. We're going to take this verdict now." And it was my client. And I'm thinking to myself at the time, as a young lawyer, well, here I am standing in front of the jury that I'm now going to be arguing this client is innocent, and they bring in a guilty verdict on another client. And
Oh, no.
I was really upset at the time. I thought, well, he should have excluded that jury from the courtroom. And I asked the clerk, I said, could I talk to Judge Swinford? He said, no, Judge wants to get moving with this trial. So I had to take a guilty verdict on my client from the first case with the jury out. And I got a brand new jury sitting in the box. And I'm thinking, well, they must believe that this guy represents nobody but crooks. The guilty. And after we recessed for the day, I asked the judge's secretary if I could speak to him. So I did. I went back into his chambers, and he never spoke to anybody without his secretary being there. And I said, Judge, I think I was prejudiced by you bringing back that jury with a guilty verdict of a client that I had in front of this new jury. And he said, Greg, I have a great deal of faith in the jury system. I always have, and I always will. And you have nothing to worry about. And I said, well, thanks, Judge. Thank you very much. That was it. I left. And of course, my next case was another guilty verdict. But I always remember that incident because Judge Swinford was so kind. And he just, he had a way about him that you're kind of disarmed when he started speaking, because it was like you were talking to God almost. He just had that air about him. But I am happy to report though, Rob, in all the years I did work down there, I did get one acquittal. Only one in all the years I was down there. One acquittal. So,
Well, we had an opportunity to to talk about some of the great lawyers that you had this chance to learn from, often only by observing. And I'd suggest that your experience there is unique insofar as it sounds like you didn't have one mentor. You learned from a lot of different lawyers, sometimes just by watching. And
I did.
I'm just curious, those great lawyers that you observed and learned from, what do you think made them so great? Why were they great lawyers?
They were great lawyers because they worked hard at preparing for the case. And that's one lesson I learned early on, especially when I got into civil work. Preparation was the most important thing. And I remember another name from the past, his name is Foss Hopkins. Very few, maybe Dave Davidson and Dean will remember him, but he was probably the premier criminal defense lawyer in the Midwest back in the 60s and 70s, 50s, 60s, and 70s. And he said to me, I sat in on a case with him as local counsel. And in fact, the case was in Campbell County. And he said to me, these cases can be difficult at times, but one thing you as a young lawyer should remember, these cases are only won or lost on cross-examination. You don't win these cases on direct examination. You win these on cross-examination. And that was so very true, so very true. And so I always made it a point when I was doing litigation myself to prepare for cross-examination in as brief and short a manner as I could, hitting the points where I saw a weakness in the other side's case. Because sometimes lawyers can get lost in the questions that they're going to ask when a witness is on the stand. And if you focus in on just a couple points that are critical or that will point out a weak spot in their case, that's all you need to do. Once you've implanted a seed of doubt in the jury's mind about the truth of the position of your adversary, you're well on the way to winning the case. So what he said to me, and he's not the only lawyer, the other lawyers said the same thing. Cross-examination, that's when you win or lose a case. Very true, very true. As it still is today.
As you moved into your practice and became more proficient, and and we always try to ask about this just to help newer lawyers kind of understand what kind of commitment or life commitment or work commitment is going to be necessary for them to become outstanding. What kind of work hours were you looking at? When you were in private practice, and maybe even on the bench as well, it was still I assume a fairly substantial time commitment.
It was, especially from 1975 when I was appointed as a part-time magistrate, and the caseload was not particularly heavy in 1975, but it was enough to have a part-time judge. And then Delta Airlines made CBG a hub. The criminal work skyrocketed. It just exploded once that happened. And that's when I realized that being a part-time judge, which was gravitating towards a full-time judge, with my private practice, which was mostly litigation, was extremely hard work. Very, very, very time consuming. And I did my best to keep above it, but it was getting to be more than I could handle. And I was doing suppression hearings for Judge Bertelsmann, I guess since starting in the early 80s. And I didn't have a clerk, of course, because I was part-time. So I was writing my own suppression orders. And it was really a difficult time. But it's also a time that I treasured a lot, because I got to meet so many really, really good people and really interesting people on both sides, on both the prosecution side as a part-time judge, and I knew all the defense attorneys too. And it was a busy time, but it was a good time, a very good time.
Well, and adding to the workload, so to speak, did you follow in your father's footsteps as far as becoming involved in the community and making those sorts of contributions?
I did, to an extent, but not to the extent that my dad did. I became a member of my wife Diana and I have 4 daughters, and they were all in Catholic schools. So I became a member of the Diocesan Board of Education, and that was a governing body at the time who made recommendations to the bishop for basically running of the school system in Northern Kentucky, the Catholic school system in Northern Kentucky. And that was really a very interesting time for me. One of the events that occurred during my tenure on the board was the merger, a proposed merger of Latin School and Villa Madonna, which created quite a ruckus in Northern Kentucky at the time, quite a ruckus. The proposed merger did not go through at that time, but it sure did lay the foundation for what we now have, which is girls and boys at Latin School. And it all started on the Diocesan Board of Education. And I was part of that. I was glad I was. In fact, we had a committee that met at least once a month. The committee, a committee of members from Latin School and from Villa Madonna, trying to discuss items for a proposed merger. Is this feasible? Are the numbers there? A lot of different items we discussed over. I think we met for a good 6-8 months. So the first proposal never did not go through, but eventually, as we all know, it became reality, and Latin School is now still the great school it's always been, but with girls attending.
I understand you're also involved, or were, and maybe still are involved in Inns of Court. If you could tell us about that, your experiences with it, and how you view that organization.
Inns of Court is, I think, one of the best social organizations for young lawyers to become affiliated with and to become members of. And the purpose of the Inns of Court nationwide, of course, is to encourage dialogue and civility between judges, lawyers, and most importantly, law students. That's why we're called the Salmon P. Chase Inn of Courts. And that organization, I've always been very impressed with the leadership of the Inn of Courts. When I first joined, I don't remember how many years it's been, but I think maybe Bob Sanders was president at the time, or Dick Lawrence, and it ran really, really well. But somewhere along the line, I don't know who it was that said it would be a good idea to have a judge become president of the Inn of Court, and maybe we could get some more attendance. And not that the attendance was poor, but they felt like if a judge's name was out there, lawyers would jump at the practice, the opportunity to attend. It's actually pretty much what happened. I think Greg Bartlett was president. I know he was president for me. I don't remember how many years he was president, but the membership started to increase. And then I think I succeeded Greg. And we would bring speakers in. Usually our first meeting was in September, our last meeting was in May. And we would bring in, if we could afford to, the national speakers who were really top-notch lawyers, and or sometimes we would bring in law school faculty from around the country. And the lawyers really seemed to enjoy hearing these speakers. One of whom comes to mind was Lynn Wood, the fellow from Atlanta, Georgia, who's had some controversial coverage in the last couple of years. But he was involved in the Olympic bombings in Atlanta back when, and he spoke, and he was really, really good speaker. And the opportunity for the students, which was the most important part, to participate in these. We always had social function, which was a cocktail hour, and a dinner and the speaker. And the law students would do some of the introductions for the guests who were going to speak. And then we did what we called pupillage groups, where the law students participated in different aspects of practice of law. One that comes to mind is taking depositions. And that was really good experience. But whoever was head of that group, whether it was another lawyer or another judge, had to prepare for that session. And I had two, and one of them was taking depositions. And we had the lawyers come down to the courthouse, and we'd start at like 8 o'clock in the morning, and we'd make sure they were out by 9 o'clock. And each one of them had a role to play. Usually we had 2 sessions before we did the pupillage groups. And the law students really, really enjoyed that. They got a lot out of it, and they had fun. If you have fun doing something while you're learning, that's good, and they remembered it.
It sounds like for the folks who will be viewing this at a later date on video, the newer or younger lawyers, check out the Inns of Court. If you've just hung a shingle, or you're a medium or a large, with a medium or large size firm, because that opportunity to interact with other lawyers and learn from them is key.
Is very, very key, very key. And they have a graduated fee schedule. If you've only been practicing so many years, you pay less than you would have you been practicing 10 or 15 years. So yeah, it's a good way to do some networking. Very good.
Well, and Judge, I understand you're still mediating cases from time to time. I'm glad to hear that. Look forward to working with you in the future on those. But looking back at your time as a magistrate, I know a lot of it was spent in mediation. I'm just curious do you have any rough idea of how many cases you mediated? It had to be maybe thousands, certainly hundreds, right?
Oh yeah. I guess I never thought about that. It probably is in the thousands because we started. I was appointed in '92, January of '92, and I think that I'd done a few before that. But once we started, then gradually those mediations increased. I'll tell you who would really know is Tammy Sigelmeyer, because she was my she runs the clerk's office now, but she was my secretary at the time, and she would have a really good good idea. But it was quite a few, but it was also enjoyable.
And with all that experience, I'd like to get your sense of, and I know we've got some folks who've joined us who serve as mediators. If you could provide us with a perspective from the mediator of what it takes to be successful as a mediator, and then we should spend some time on what you hope that the parties accomplish prior to and during mediation to help achieve a successful outcome for the mediation. So your views on what it takes to be a successful mediator and what parties should do to help the mediation be a success.
Well, there's a lot there, Rob.
There is, I know.
That's all right, because I really did enjoy doing the mediations, and believe it or not, it saved a lot of people from having to go through what we, as trial lawyers, we all know can be extremely difficult stress of a jury trial. But as far as the mediator himself or herself, I think it's important that number one, the mediator always takes himself lightly and the litigants very seriously. That's rule number one. And rule number two, you must be a good listener. You have to listen to what the parties have to say. For most everyone who participates in mediation, that event is the first time that all of the parties are together in a neutral environment. And I usually start off the session of mediation by telling the litigants that you're here with the consent of your counsel, usually, in an effort to resolve this case without the necessity of having to go forward with trial expenses, and most importantly, the stress of going through trial. And I also made it a practice most of the time not to have any opening statements, because those can sometimes torpedo a successful mediation. And I think every mediator has their own philosophy on that, but I learned over the years that you're better off usually not having opening statements. But I do ask a couple questions at the beginning of my mediation, which are focused on what I said to you earlier about cross-examination. I try to get to the gut issue, what are the critical issues in this case, and ask some questions. But after a number of years, Rob, of doing mediation, I learned, I think I've said this to other attorneys before, I rarely sat through a mediation that I didn't learn something that I didn't know before. Might be trivial, but it's just a little tidbit that I picked up. One of those tidbits was, in a case where there has been a death or a traumatic injury, it was so important to the family of the person who died or the person who was seriously injured to hear somebody in that room say that I am sorry for your loss. I truly am sorry for your loss. I'm sorry for what happened here. And I certainly would not want to go through what you're going through. But we're here today to try to resolve this case, and we'll do the best we can. And I started telling attorneys, primarily defense attorneys, that I thought that would be a good idea, especially in wrongful death cases, because I continually heard the same comment from family members. You know, my husband, my wife, my child, it's not just a number. It's not just an inanimate object. This is my life. And nobody said anything about what we've lost here. Not even an apology. So after hearing that comment more than once, I started suggesting to lawyers that on those type of cases, that they make that effort without conceding anything. Just you phrase it well, and that will help this mediation along. And it sure did. I really learned a lesson there.
Well, what about the subject of all the raw emotion in a mediation? I mean, some mediations don't involve that, but others do, and not just with respect to that loss, but you know, how do you deal with, you know, openly expressed anger and frustration as a mediator? Do you just you just kind of sit back and maybe hope that if that sort of venting occurs, that's their forum? Or how do you manage the emotions there?
It's a difficult thing to do, Rob. It's very difficult. And I depend on the lawyers to tell me that ahead of time if they anticipate that's going to happen, that my client could get upset. There might be some tears, there might be some accusations, and if I know that ahead of time, then I'm prepared. And that, thank God, it doesn't happen that often. But if it does happen, I usually ask the person who's showing the emotion to take a break and said, "Would you like to take a break now, or step outside?" And usually the lawyer will get the cue and do whatever is appropriate at the time. That is one thing that's really difficult to deal with in mediation. And that is overcoming the emotions of the party who feels that they've been wronged, and that the efforts to get this resolved are being minimized or borderline frivolous. And that's where the mediator's work is cut out for them. That's where the listening comes in too, because those people who lose their composure and get upset during mediation, they're the ones who need most the opportunity to vent. They need for somebody to listen to them, somebody to show concern, somebody to show care. And that's what the mediator is supposed to do. It's not an easy thing to do, though. Not an easy thing at all. And if it gets out of hand, Rob, I just say, let's take a break. And we will take a break. But fortunately, as I said, that has happened. The attorneys who, if they're listening, attorneys who participated know it's a very difficult time. But I normally, after that happens, Rob, I normally say in private to the attorney and to the litigant or the person who got so upset, that I completely understand, especially in a wrongful death case. I completely understand why you're so upset. And that's why you're here today. You've had this opportunity to vent. You've had an opportunity to tell someone who's completely neutral in this case why you are screaming mad and why you're hurt. I would prefer that you do it today, though, and not 6 months from now in a courtroom. And usually,
well, as far as the parties that come before you, because I trusted you, I felt like I could come into the mediation and say, Judge, here are my two problems with the case. Here's the problem that my side has with the case. Here's why we one of the reasons why we're here, to try to resolve it. And I felt like I could be honest with you and that you wouldn't take that information and misuse it, that you would calculate it into your analysis of how the mediation was going.
Yeah.
And then you could steer the group collectively towards the right outcome. Maybe that was just almost I don't know how many other parties do that, but what's your perspective on, the a party to mediation being, more unvarnished with respect to candor about weaknesses?
I, I think that is a critical part of a successful mediation, is that the litigants let the mediator know that I've got a problem with my client. I can't say this negative issue point to my client. And I tell the lawyers, that's where I come in. I can do that. I can say that to them. And I tell the attorneys, if I see that coming up, I'll tell them privately, of course, if you've got a weak spot here, if you've got a communication problem with the client, I need to know that, and I can address it. Far better it comes from me than it comes from you. And I do that. And it's been successful. It's worked. But the most important thing is the people who come in for mediation, they've got to feel like someone is listening to my position. That's not just the plaintiff. That's the defendant, the third party defendant. It's all the parties. That's why I think it's important in mediation that the mediator have good eye contact with the parties speaking. You can tell a great deal about a party's feelings, emotions, demeanor, just by watching their eyes, watching their face, watching their movements. Body English, very important, very important. And you pick that up after a period of years. And boy, I have had, over the many years I've been on the bench, I have had some absolutely gut-wrenching cases, some of which would bring tears to your eyes if you knew the facts of the case, as the lawyers do. And if the lawyers listen into, they know which the cases I'm talking about. I often thought maybe I should do like you, Rob. I should write a short book about some of the cases I've heard, but I can't do that because the mediation, of course, is
confidential.
It's confidential. Yeah, but sometimes I think back on some of the cases I've had. It's mostly the death cases that really trouble me, even years afterwards. And thankfully, most all of them settled, but they were real challenges.
What were the qualities that you looked for in the lawyers who practiced before you when you were a magistrate? And I think this is maybe particularly helpful for the younger or newer attorneys. What inspires confidence in you as a judge from a practicing lawyer before you?
I think most judges appreciate the fact that the lawyers are candid, that they don't try to sugarcoat anything, which is a word I use in my mediation sessions. I tell the litigants when I come in, I promise you I will not sugarcoat anything here. I will tell you as it is. That's the only way a case will get resolved. And I expect, and I appreciate the same thing from attorneys coming into court, whether it's a civil case or a criminal case, that they be candid. Don't try to run one by the court. Don't try to paint a picture that doesn't exist, because I will appreciate far more and can be far more effective if I know exactly what you see as the issue here. And if it's going to hurt your client in one aspect but benefit them in the other, you got to tell me. You're going to tell me both parts. And I there's no absolutely no substitute for preparation, none whatsoever. If you know your case, the judge will know that quickly. And if you don't know it, judge will know that too, pretty quickly. So preparation and candor are what a successful lawyer is all about. You do those two things, you're going to be successful. You're going to be good, and that's kind of the way I practice too.
As far as, I mean, this ability to, I guess we're talking about your exposure to the law is through the course of 6 decades, maybe I don't know, maybe 7, with your upbringing, but with that ability to see lawyers practicing in the 50s, 60s and such, and then see them practice today, what are your views on civility in the profession? Are we doing better? Are we doing about the same? Is it important? How do you view that?
It is important. It's very important. I think, and I've said this to lawyers that I have had unknown for years, that in our area, I'm talking about Northern Kentucky, Cincinnati, just basically the local Midwest, the instances of lawyers who are uncivil, who, other than one rare exception, our reputation here is decent. It's very decent. And I can say that without a doubt, the only instances that I can recall from my time on the bench where I had attorneys who maybe weren't divulging all of the discovery that they should have, or attorneys who had supposedly, allegedly destroyed records. They were not local attorneys. They were not local attorneys. And I often mention that too. I mention that to Judge Bertelsman, Judge Bunning. We used to have I think they still do have monthly luncheons. The judges from Covington, judges from Cincinnati would get together once a month for lunch. And sometimes that topic would come up. And I think they all agree that the instances of incivility are rare with our bar, with our local bar. Really, I can say from my experience, they're rare, period. But on the occasions when they did happen, rarely was it local. Rarely was it local. And thank God I didn't have to deal with that. I can only recall, I could be wrong on this, but I think I only had to sanction maybe 2 times in my entire career I'm talking about for discovery abuses. So that says quite a bit.
Well, that's encouraging. And I know that I don't think you ever sought a lot of public attention when you were in private practice or on the bench, but there was this event 12 years ago that put you in a little bit of the limelight. And I'd be remiss if we closed out this interview without providing you with an opportunity to talk about that a bit and why it's important, why it's an important message for you to communicate.
Well, you're talking about the kidney transplant. That was 2006, June of 2006. And it really became an event that neither E.J. Wehrman or I could ever have anticipated. We had a strict rule, as the attorneys are listening now can verify, that you're not allowed to bring your cell phones into the courtroom. And one day, E.J. Wehrman asked for permission to bring his cell phone into the courtroom because he was on a waiting list for a kidney. And he said if he gets a call, he has to respond immediately. And I said, sure, you can do that. I have no problem with that. And after court was over, I asked the clerk, Kim, to ask EJ to come in office. And I said to him, if you need any help, I would be honored to consider donating to you. And he said, he was surprised, and he said, well, thanks so much, Judge, but my wife is on the list right now, so I think everything's going to be good. And I said, well, that's good, EJ. I'm happy to hear that. And then about 3-4 months later, he came back in the office and he said, well, is your offer still good? He said, my wife didn't pass for some reason. I don't remember what it was, because they're extremely rigid about conditions for a donor. And I said, yeah, it's still on the table. So that started a series of tests at the Christ Hospital. It went over a period of about 4 or 5 months, I think. And then June 20 of 06 was the transplant, and everything went really, really well. EJ and I discussed, and I know his family would not care if I mention this to you, because I think most attorneys, and certainly the assistant U.S. attorneys, know this. EJ and I discussed making this donation public, and we both agreed that it would be a good thing to do, because there is such a need for live donors. There's need for any type of donor, whether it's a cadaver or live. But he had been on dialysis for quite some time, and he said that dialysis was just so difficult. He went 3 times a week, and he said, you're just completely wiped out after dialysis. And then when you get to feeling much better after 2 days, back you go, and you go through it again. And he said it was really, really tough. So after the transplant, EJ, it was just a short time after the transplant, EJ said to me, I have more energy now than I've had in so many years. I just can't believe what a difference this is, what a difference it makes. And so we both thought, let's just go public with this, and hopefully we get some more live donors. And I don't know whether we got more live donors or not, but the publicity certainly generated a lot of interest. And then Christ Hospital asked EJ and I if we would do a film, which I don't think many people know. It was about 1 year after the transplant. Asked if we would do a film as donor or donee about the process and the procedure, which of course we agreed to do. And you never know who's seeing these films, who's watching these films. But I found out purely by accident many years later that one of my grade school classmates was in need of a kidney, and she had seen the film, and it was really kind of neat. She was just so surprised just to see one of her classmates being a donor, and I still hope to this day that many people that remember that will give it some thought, because the need is still there, and it is still a great need. But I would do it again today. And EJ died January 3 years ago, I think. 3 years. Anyway, his diabetes was he just fought the good fight, but he lived almost 11 years afterwards. So,
looking back on your time on the bench, what do you feel best about?
Well, that's a good question, Rob. I can tell the lawyers who are listening that I sincerely and wholeheartedly miss seeing the lawyers that I dealt with. I really do. And I do get to see them periodically now through some mediations, private mediations I'm doing, but that one-on-one contact is something that I really miss. And I just hope that the attorneys who may be down the road or listening to this will understand that it's important. It's important for every lawyer to show some respect and to show the judges that they appreciate the work that they do on the bench, and that they are prepared and that they are ready to go. That's the most important thing. And I've been very fortunate in that regard. Very fortunate, which is why I miss what I do, what I used to do. I miss it a lot.
Well, I see we have at least one question here, but just to move towards our wrap up, I like to ask every legend we interview to tell us something not widely known about them that people might find interesting.
I've been thinking about that, Rob. I don't know how to. I don't know how to answer that. They might find interesting is when I was in the prime of my practice and even on the bench, I didn't have much time to do any reading, but I am now, and I really enjoy that. I'm really catching up from years of being so busy I couldn't read at all.
I understand that.
Yeah.
And
yeah.
Before we move to Q&A, words of wit and wisdom for the next generation of Northern Kentucky lawyers.
Well, my words of wisdom are: keep a low profile, be humble, and always be prepared. Your work will show others what you are made of and what you're capable of doing. That's all you need to do.
That's great. Thank you. And so
Thank you,
here's a question from Dave Davidson. Hello out there, Dave. He says, it is said that juries often know the decision by the end of the opening statements. Have you heard that? And do you think it's really true?
I have heard that. I do not think it's true. I do not think it's true. And the reason I say that is because if the voir dire is done correctly, jurors are not supposed to make up their mind until they've heard the evidence, much less at the end of opening statements. I can see where somebody might think, because one lawyer was far more presentable than the other lawyer, that the case is over with, but I don't think that's the case at all. That's a good question, though, Dave. That's a very good question.
It looks like we've got another question that's come in, perhaps. Dean Piscano wants to know, has your handicap gone down since you retired?
Only Dean would ask that question. Yeah, Dean, it's gone down a little, but not much. Just about one stroke, maybe. I don't know. Yes, Dean, it has.
Good question. Not getting older, getting better. I like that.
Yeah,
and
me too.
Hey,
so
Judge,
thanks so much, Rob. It's been a real honor.
I just want to thank you for passing on your experiences. And again, this program is principally for the next generation of Northern Kentucky lawyers, and wanted to offer my personal thanks for all you've done for us through the years in the Bar Association. To wrap up, as always, for live attendees, our spectacular NKBA Executive Director, Julie Jones, is going to be sending you CLE forms and information. Feel free to reach out to me at rhudson@fbtlaw.com or to Julie with your suggestions about the 2022 lineup of our NKBA Legends program, and with any other suggestions you may have. We want your input always at the NKBA. And so for our live attendees, thank you for joining. Hey, we're coming up to the holiday season. Stay safe, stay warm, and may you have many wonderful family and holiday blessings. Everybody have a terrific day.